Welcome everyone. It is the Gun Rights, Know Your Gun Rights webinar. I'm going to call it a webcast because the way I've set this up for my law firm, the Missouri DWI and Criminal Law Center at the Benjamin Law Firm, is that I'm going to bring on guests and do this at least once a month and different legal issues that we will discuss based on my friends who I know in the legal community who specialize in certain areas of law. I'm a criminal defense lawyer and I specialize in DWI defense and criminal defense generally, guns, violent crimes, drugs, sex crimes, all of that. But there are certain people in our community who really become specialists in an area of law. And that is why I want to welcome here today Kevin Jameson, who is a lawyer in the Kansas City metropolitan area. He and I tried a case together many moons ago. And right now he's having technical difficulties. He can see me, but he can't get the camera or the audio to work from his end. So he has called me on his cell phone and we're going to try to make this work. Please, in the chat, tell me about the sound. Kevin, go ahead and if you would, introduce yourself a little bit and we'll see how people are hearing you.
I'm Kevin Jameson. I've been practicing law for 37 years in the area, concentrating in weapons and self-defense. And there are a lot of brand new gun owners out there, and I hope some of them are listening.
Yes, Kevin and I both are of the same ilk. And by the way, Kevin, Brett and W.W. Bland are saying sound is good, so this is fantastic. But Kevin and I are both of the same type of criminal defense lawyer. We want to educate the public. We want to help you. We don't want to see you in trouble and have you be a future client. We want you to know your rights, also know the law, and maybe educate your friends because there's a lot of misinformation out there, tremendous amount of misinformation, and those people end up becoming our clients. So Kevin, you agree with me on that?
Yes, and the Western Missouri Shooters Alliance has got a stay out of jail card on their website. It's WMSA.net. And of course, you can get a cardboard copy of it. It's a wallet-sized card that summarizes Missouri weapons and self-defense law with the object of keeping you out of jail.
That's great to know. Well, Kevin, I actually have a friend texting me right now who wanted to be on this webinar. I'm going to send him the link. But how we wanted to get started, folks, is that we wanted to give you a little bit of the history of gun laws and a little bit of history of the Second Amendment, because Kevin and I both hear a lot of people talk about the Second Amendment and their gun rights, and frankly, there's a lot of misinformation and misunderstanding about what our history is in America with gun rights. And so, Kevin, if you want to start there, I think that'll be a helpful place to start.
Well, way back when, the British in Boston required everybody to turn in their guns, and they were told that they would get them back. And the British lied. And of course, there was that day in April of 1775 when they came out and tried to collect people's guns, and people shot back, and that started the revolution. There have been certain categories of persons from the very beginning who were denied guns. Slaves, obviously, that if you let slaves have guns, that would make the practice a little bit dangerous. Indians were not allowed to have guns, and in the colonial period, Quakers were not allowed to have guns, because if you let pacifists have guns, God only knows what would happen. But Quakers were being persecuted in those days, and they didn't want to get shot at. So this continued throughout our history, where under one subterfuge or another, a certain category of persons was disarmed. And sometimes it was aliens, sometimes it was newly arrived immigrants. Some, by various subterfuges, African Americans, even after slavery. So it has been discriminatorily enforced from the get-go. And the process has been accelerated recently on stopping that discrimination.
And so in America, the Second Amendment, just to give everyone an understanding of what it is now in this country, the Second Amendment is what exactly? Because some people think it's the right to bear arms, they can bear anything they want to bear, that there's no limitations, and some people have very strong beliefs about limitations.
Well, the Supreme Court said that commonly used arms, commonly used weapons, firearms, are protected under the Second Amendment. And the AR-15 is the most commonly encountered rifle in the United States, a commonly owned rifle in the United States. And so these attempts at banning semi-automatic firearms have been successful, but we're still waiting for the Supreme Court to rule on a standard of whether or not the Second Amendment is triggered. Now, it would appear from the Heller decision and McDonald's decision out of Chicago that it would seem that it's a strict scrutiny, because they talk about it being equivalent to the First Amendment. But the Supreme Court has not specifically said what standard of review is required. And at the very lowest level, there's the reasonable basis that if the government come up with any possible excuse that makes the law valid, well, the individual loses. And under strict scrutiny, the government is almost always loses. It's a very rigid employment. But the Supreme Court has not said specifically what standard is employed. Right now, the appellate courts have been doing intermediate scrutiny, which enables them to balance the rights of the individual and the interests of the state. And they've been balancing against the individual for the most part. There are several cases that are in suspense in the Supreme Court docket that have not been scheduled for hearings and briefings and so forth, but the court has not rejected them yet either. And so until they take one of these cases, we're not going to know what standard is required. And that will, once they give us that information, that will change everything.
Well, what do you mean that will change everything? What does it mean to the average listener who's not a lawyer? They just want to know how to stay in the lane of, I don't want to be arrested and get in trouble for owning my guns and using my guns.
In Missouri, it means very, very little, because there's no law against owning semi-automatic firearms. And I got a call from a lawyer in Massachusetts once. His client was moving here, and he says, well, he asked, what do you have to do to own a semi-automatic weapon in Missouri?
Nothing.
Well, pay for it. That essentially is. And he was asking all of these things that we just don't do, but Massachusetts does. And so we have to find a nationwide standard that determines how do we look at infractions of the Second Amendment, and how rigidly do we evaluate the government's interest in banning or restricting these guns.
So you brought up a good point. Somebody wanted to move from Massachusetts to Missouri. So let's talk about transporting weapons in general across the country, or if Missouri is touching more states than any other state in the union. So anyone who's listening could be near another state very easily. Kansas, Illinois, Nebraska, Iowa, there's so many, Kentucky, Tennessee, Arkansas, and Oklahoma. So what are the rules for those individuals who want to have their weapons in their vehicle and travel across state lines?
Well, first you have to check on the states that you're passing through. Now, federal law says that if you're transporting a gun across state lines, if it's legal to own in the state that you started from and the state you intend to end up in, you can travel through all the intervening states if you're on a continuous journey between the 2 points and the gun is unloaded and in a locked container not accessible from the passenger compartment of the vehicle. So you have, but there have been some cases where a person has stopped for one reason or another. There was a guy traveling through New Jersey, stopped to take a nap, which seemed to be a safe thing to do when you're driving, and the state police investigated, found the gun, and the judge says, you were not in a continuous journey, you stopped to take a nap, it's 5 years in prison.
Wow.
So he got pardoned later, but these people crossing state lines thinking that their license to carry covers them in other states, it doesn't. And you have to check and plan your route, because if you're going from Missouri to Nashville, Tennessee, then if you travel through Illinois, you don't have an Illinois firearms owner identification card. You just committed a crime just by crossing into the state.
Even if your weapon is in your trunk and you're just, traveling with your weapon for safety reasons?
So if it's unloaded and locked in your trunk is the easiest way to do it. Then you're protected under federal law, but God forbid you should stop and take a nap. There have been several people who've traveled by air, unloaded their gun, and it's in a locked, hard-sided container. They're diverted to an airport in Illinois, New York, and when they unload the airplane, they try to check it back onto the new airplane. They're arrested for possession of a firearm without a state ID card, which is practically impossible to get. And so far, the courts of appeal have put up with this. So if you're traveling by air and you're diverted to another airport, insist the airline secure your gun and accept no excuses. There is just no possible way that the courts are going to allow that to happen. You'll get arrested, and you may be fined, or it may be a very minor result, but it's going to cost you a great deal of money.
So if you're traveling in your car in the United States, the safest way to be protected by federal law is to have your weapon in your trunk unloaded. Is that right?
Yes.
And the safest way, if you want it in your car for safety reasons, with you in the front of the vehicle, what is the safest way to be able to travel all 50 states? Or is it impossible to know because it's a different law per state?
It's a different law for any state. And there is a website called handgunlaw.us, which is on the stay out of jail card, that will tell you what the law is on the various states.
Tell me that
and
website again.
And Indian reservations. Indian reservations may have different laws. Indians have had bad experiences with white men carrying guns, and they're a little sensitive about it.
Kevin, can you say that website again? I'm going to type it into the chat for the folks who want to look that up. Hand law.
handgunlaw.us.
Oh, Ken Williams just posted it. There you go. Okay. Someone has asked a question. If I stop at a hotel, is that considered, safe? Is it continuous? You talked about the guy stopping to take a nap in his vehicle. What if I go to a hotel?
It would depend on what state you're in. These states that have firearms on our identification cards, you're probably not, no.
So
certainly not.
It's worth researching your route, knowing which state you're going to travel through, and that handgunlaw.us gives you those answers. Is that right?
Yes.
Okay.
Yeah, it's very extensive and has a very good explanation of what obstacles you find in these states.
That's great. That's good to know.
The Missouri concealed carry license is valid in 35 other states. It's recognized, but you still have to obey the law of the state you're in.
Right.
Because if they say that you can't possess a firearm on the street in front of City Hall, and you've got a valid Missouri concealed carry license, well, you have to obey that fairly silly law. But
right.
It is worth checking out this website before you start your trip.
That's good information to know. Let's talk a little bit more about Missouri specifically. Let's talk about your open carry rights versus your concealed carry rights in Missouri.
Well, you can carry openly in Missouri if you have a license to carry concealed. Now, yes, I said that right. To carry openly, you have to have a license to carry concealed. This is frankly because when open carry became legal, a lot of guys were clinging to their rights, and the police would get calls about a man with a gun, and they'd show up and they'd say, what's your name? And he said, I don't have to tell you.
Right.
And it's true. You don't have to tell the police officer what your name is. And this is frustrating because the police officer has responded to a call. He has to make a report. He has to say who he talked to, and the guy won't tell it. And I've seen videos of people who were sitting there for half an hour refusing to identify themselves, and it involved sergeants and lieutenants and so forth. And so they changed the law to say if it's illegal in that city to carry openly, you have to have a license to carry concealed, and you have to show the license if asked by a police officer under any circumstances. Even if you don't have a gun, you have to show the license if asked. So that solved what the police perceived, I think, reasonably as a problem. And it's a minor thing that does not intrude very, very much on a person's rights.
So if asked, show your carry concealed card. Let's talk about what does it mean to carry concealed, and how are you allowed to carry concealed? Because there's your person, your car, obviously around your own home or in your own, maybe your yard, and the neighbors see a gun and they get scared.
Well, certainly on your property, inside, outside, you are allowed in Missouri to carry concealed even if you don't have a license. But there are certain circumstances where if you're carrying concealed and you go into a place where they've got a sign on the door that says no concealed weapons, no weapons, whatever, and you don't notice the sign, you walk in and people find concealed weapons all the time, and they find you've got a weapon on you, you don't have a license to carry, you're carrying under the permitless law, it's possible for you to get arrested, possible to get 6 months in jail. It's possible. I haven't heard of it happening, but it is possible. having a license to carry means it is unlikely that you'll be arrested under any circumstance, even if you go into that banned area. But you will be charged with an infraction. You'll get a fine, and it goes on your record. So it is much better to have a license to carry. If you have the license, you'll at worst be charged with an infraction, which is not a crime, and it's punishable only by a fine.
Right.
It's not good to have an infraction on your record, of course, but it's not a crime. So having the license to carry is an advantage. It avoids certain possibilities.
Let's talk a little bit about how I and you see a lot of clients, how people get arrested and get into trouble. One of the ways that I see most often is for someone exhibiting in an angry or threatening manner a gun. And there's lots of defenses, and we'll talk about that generally. But let's talk, what is the unlawful use of a weapon by exhibiting statute? How do people avoid getting arrested for that crime?
Okay. It's exhibiting a weapon in an angry or threatening manner.
Right.
So if you pull back your coat and show that you have a pistol and you threaten somebody or you cuss them out or something, this is exhibiting, or sometimes called brandishing. And it is
Also,
all the cases I've read on it have involved pointing a gun at somebody or holding a gun while making threats. And the best way out of this is to read Miss Manner's Guide to Excruciatingly Correct Behavior. It's 826 pages, but I'll summarize it as: do not make other persons uncomfortable.
that is true.
Some people are uncomfortable simply because guns exist and gun owners exist. But the best way to stay out of trouble is good manners. They can keep you out of trouble better than Kim and I can keep you out of trouble. It is very all the cases I've seen on this, people have been cussing out somebody while holding a gun of some kind, or any weapon. If you're holding a machete or something, it could happen. I've never seen it, but it's possible.
No, I've seen it. I've seen exhibiting of knives for sure. But specifically with guns, I've seen a lot of people get in trouble, and I've had these cases where one case I had was a person was very uncomfortable at a local bar. They went out to their car, and it felt like a mob was coming after him because everyone wanted to watch the guy who's coming after him. So a group came out. He goes into his vehicle, he grabs his gun, he shoots into the air, a warning shot. I've had at least 3 of those cases where the person feels fear, so they try to use their gun to show, don't mess with me. Like a road rage case. I've had multiple road rage cases where someone doesn't shoot the gun, but they show the gun just to say, don't mess with me. And all of those people get arrested and charged. And sometimes it's because they're firing a weapon in city limits that don't allow firing. Other times, and that's usually an infraction, or they're getting a big felony for exhibiting. So let's talk about how to be smart about guns. Yes, it goes back to be smart, be kind, the mismanners, but sometimes people are scared, or it's more than anger. Angry, road rage is definitely an anger situation, but anger comes from being scared. What's the best advice we can give people on how to deal with that?
Okay. Very often it's also shooting along or across a road or at a house or something. That happens a lot. I've seen a guy who the neighbor's dogs came charging at him, and he fired a gun as a warning shot, and he got arrested for brandishing and firing a gun. It happens a significant amount of time, but you can avoid these things by keeping your gun in a holster. If you're threatened, if you you have a mob of people coming at you, yes, you can draw a gun, and the very presence of a gun will often cause them to retreat. Firing a warning shot is dangerous. The bullet has to come down someplace, and it almost always comes down in a bad place. And if you fired a warning shot, somebody gets hit, that's second-degree assault. And that carries some significant jail time.
And God forbid the person didn't make it, second-degree murder.
Yeah, yes, that's true. There's a case that's taught at the police academy where a guy shoots a warning shot in the air and it bounces off the ledge of an old building, comes down and hits the guy on the top of the head. So that looks like an execution, and it's a very bad circumstance. So no warning shots under nearly any circumstances.
I agree.
I have heard of people who fired warning shots and driven off vicious dogs and so forth, but it is dangerous.
I had that exact case several years ago in Lafayette County. I was a new attorney, and a woman was scared by a dog and shot a warning shot trying to scare that dog away from her. She thought she was going to be attacked, and unfortunately that bullet ricocheted and killed that dog. And she was charged with the crime, and the jury said not guilty. But boy, that was a stressful time in that woman's life, not to mention the poor dog owner. It's just a no-win situation.
You know, there's bail and there's court costs and there's money for lawyers, and it just leads to all kinds of trouble. Generally speaking, if you fire a warning shot, the prosecutors think that you were not sufficient danger to claim self-defense. And I would argue otherwise in certain cases. But you can get away with that by carrying pepper gas and using that instead. If you carried everything you could possibly need, you'd find it difficult to get your belt buckled. It's a solution. I would personally, I advise against warning shots.
Well, let's talk also about, David asks a question. Can you shoot an attacking dog? That's self-defense.
Yes.
If a dog's attacking you, absolutely you can shoot an attacking dog. That's
Yes.
self-defense. You agree, Kevin?
If the dog is placing you in jeopardy, has the ability and has the means to do you harm, that's the reasonable fear standard. You have to be threatened by a barking dog or a barking person. He has to have the ability. He has to be close enough to carry out the threat. The dog is inside of a fence. He does not have the ability to get at you, and he has to have the means. And the dog always has the means. His teeth, his claws, what have you. So that's the jam elements. And other professionals use different acronyms for the same thing. So if you're listening to somebody else talking about a reasonable fear, and they use a different acronym, don't worry about it. It's just they invented the other acronym. They're fond of it. I like to say it's, you have to stop and think, did Jameson say jam or jelly? And it's jam. So.
And state your acronym again. JAM stands for what?
Jeopardy, ability, and means.
Right.
There's a threat. They're close enough to carry out the threat, and they have the means to carry out the threat.
Right.
And one instructor at the ATF office says, if you have to stop and think if you're in fear of your life, you're not. It should be fairly obvious, but to organize your statement later on, we use these jam elements.
Right. So another thing thing that I have found in my career as an attorney is I have had many clients who are out just to have fun. I've had 2 on July 4th who took their weapon out just for play. Unfortunately, both also had alcohol involved. So let's talk about, and also kids who take a weapon and shoot at mailboxes or shoot at empty houses while they're driving down the road. And there's a serious statute that everyone should know about. If you're shooting at a house or from a car or at a car, it's 15 mandatory years in prison, no probation, no parole, 15 years. So the kids in the country where I grew up in Cass County in Harrisonville, Missouri, we all would go out in the country all the time, and kids in Missouri take their hunting rifles and shoot at things like trees, mailboxes, maybe a deer from the car. You cannot do this without facing 15 years in prison. And let's talk about that. People going out to have fun, they end up finding themselves in some serious trouble, Kevin.
Yes, I heard of that. In fact, I had a client charged with shooting at a house, and he said, well, I wasn't shooting at the house, I was shooting at the car parked in front of the house.
That doesn't help.
I said, same OGI, it's the same penalty. Now, there were people in the house, and there was no one in the car, so perhaps he was trying to misdirect me, but it doesn't make any difference at all if there are people there or not. And you see a lot of these gangbangers doing drive-by shootings of houses. And I had a client with a little 3-year-old girl. She was killed because the gangbangers shot up the house.
And that the statute was written by the legislature in Jefferson City for things like that, road rage and gang banging crimes.
Yeah.
But unfortunately, it doesn't carve out any exceptions for the country kids who are driving in the country shooting at mailboxes, and some neighbor hears gunshots and calls the cops, and the cops find the kids, and they're facing 15 years.
Yes, and the parents say he's a good boy. Well, the law says he isn't.
Unfortunately, worse than that is we find that the prosecutors often don't care. That's the hardest part, is that they don't understand that the statute was written for a certain type of criminal activity, and instead it swoops up all these really innocent kids who are just doing stupid things because they could hurt someone, including themselves. But they're not trying to hurt someone. They're just being reckless.
Their daddy told them that he used to do that, and the law was quite different in Daddy's day.
That's right.
It's a felony, and as you say, some of the prosecutors are trying to build up a conviction rate, and when they find an easy case, well, you're helping their re-election campaign by just saying all I was doing was shooting at the house. I didn't know anybody was there. It doesn't matter if anybody was there.
Right. There was a case I had years ago where a guy stood on his back deck in the country. He has 10 acres. He thinks it's safe. And he's shooting his rifle at trees in the woods behind his home. Lo and behold, if that bullet doesn't find its way through the forest into the home, over 10 acres away. Guess what? They called the cops. Thankfully, no one was hit. They called the cops, and that guy was facing serious charges. So it was a felony.
Yeah.
Assault.
Yeah. Well, I've seen people who set up their own little range in the backyard,
right,
thinking, I'm out in the country, it doesn't matter, and bullets escape their range, their primitive range, and endanger people, if not kill them.
Yeah.
I've had clients like that. It's dangerous. It is dangerous as all get out. And I've had people take me out to places in Platte County where they've always been shooting.
Right. For years.
And grandpa used to shoot out there, but it's changed. People have built houses out there now, and I would no more shoot in that area than I would in downtown Kansas City. No. There might not be people there, but there could be. And it's just, we have some very good established ranges in the greater Kansas City area, and people should use them.
Very good point. There are safe places that have been created for shooting. Unfortunately, there are people that just want to go out in the country and shoot, and that's when bad things can happen. You could go years with nothing bad happening, and then all of a sudden something bad happens.
Yes.
I've had hunters who accidentally were too close to a road and their bullet hit a car. These are, it's dangerous, and it's also something that's going to get someone in trouble. Let's talk about alcohol. I've had clients who have guns in their homes. They're drinking in their own home. They're not doing anything wrong. They're not bothering anybody. But they find themselves in hot water and get themselves arrested because they go touch that gun when they've been drinking, and that is a felony. Someone gets scared because they see a drunk person, and that's usually what happens. A neighbor, or the gun got fired because they're just messing around in their house and they shoot into their ceiling because they're not paying attention. But alcohol mixed with guns is going to get you in trouble. Let's talk about that statute.
Well, it's if you're drunk with a gun, there have to be three elements. You must be armed, intoxicated, and do something stupid.
Right.
You have to be, the gun has to be handled in a dangerous or unlawful manner.
So that doesn't mean doing something stupid does not mean actually firing that weapon.
Don't have to fire it. You just have to wave it around.
Right.
And the standard for intoxication is not the DWI standard. It's possessing a gun in a dangerous or unlawful manner. So if you're asleep in the front seat of your car behind the wheel, and the car is parked, you can be convicted of DWI.
Right.
Possible. And we've had some very amazed clients convicted of that.
Yes.
But if you're asleep in the front seat of the car, that's not enough. You must possess it in a dangerous or unlawful manner. And that can be waving it around, that can be threatening people with it, that can be firing the gun off outside of a range. And there was a case in southern Missouri where a guy was convicted of manslaughter, and the appellate court said he violated the gun safety rules, so that's enough for manslaughter. If you're going to do any drinking at all, lock the gun up and then go have fun, but don't carry it with you.
I agree. And if it's in your house, don't have access to the gun safe. You know,
right.
That's the thing is that when people are drinking and they get really intoxicated, they just don't care anymore, and they want to go play with their gun, or they're in the country and they want to shoot it off their back deck or shoot it in the house, God forbid. That's where like you said, that's where bad things can happen and people get arrested. The intoxication standard, let's talk about that briefly. Intoxication is intoxication, and it's per se 0.08, which is 4 beers for a DWI. 4 12-ounce cans of beer can get you to a 0.08. You don't have to feel tipsy. You don't have to certainly feel drunk. You cannot feel it at all and still technically get yourself in hot water for a DWI. So intoxication related to weapon possession and using your weapon. Kevin, speak to that. How different is it, if at all?
It doesn't use the 0.08% blood alcohol content, but I've seen that referred to in every drunk with a gun case I've seen since it became a felony. So you really only have to be possessing the gun in a dangerous or unlawful manner. And that can be anything about waving a gun around or pointing a gun at somebody, firing the gun. If you look at the Brandishing Statute, it's very similar. So if you're drunk, it is very difficult. It's more difficult to convict a person of being drunk drunk with a gun than it is for DWI, because for drunk with a gun, they actually have to be doing something.
Right.
Now, it may not be very smart for them to be just sitting on the front porch holding a gun while they finish off a fifth of Jack Daniels. But when you drink, those little alcoholic demons get into your brain and say, let's see if the gun still works. Or let's just sight down on that car on the highway.
Right.
That's enough. That's unlawful use of a weapon. You don't have to fire it.
I agree. We had a question in the chat about where are the statutes in the revised Missouri statutes that we've been talking about. It's the chapter on weapons, chapter 571.
571. In general, yes. There's a few other statutes, but that involves the authority of local government to regulate firearms and ammunition. They can't be more restrictive than state law.
Right.
And things of this, you'll find just about everything you'll need to know in Chapter 571, but you also have to follow federal law, and federal law will affect carrying weapons and possessing weapons, and it is that's something that you'd have to look at. And it's at 18 U.S. Code Section 9.
I'd have to Google it. I can't remember it either.
It's exception 900 or something up to 923 or 926. 921 through 926, yes.
Right.
And if you just go to the ATF website, they've got copies of all the federal statutes there. They will not answer your question about it, and they've got a very nice website, very good website.
Yes.
And very easy to look at, and they have common questions that you could click on. But if you call up the ATF, they're probably not going to answer your question, and you have to call up one of us. And I've got people who call me up all the time asking me, I've got a felony record, can I possess a gun? And that's very easy to answer, even at 2 o'clock in the morning. No, you can't.
Right.
You cannot have access to a firearm, which means you cannot, if your wife has a gun, you know where she keeps it, and you can, you committed a crime.
Well, and Kevin, on that topic, I've interestingly had the ATF advise a client that he could live in the same home with the gun that his wife owned. It had to be in a locked safe, and he can't know where the key is. And once he knows where the key is, then he's in trouble.
Yes, exactly.
And felony.
If some of his property, his Rolex watch, is in the same safe as the gun, they're going to suspect he's got the combination.
Right.
And you really don't want that kind of problem, because if you look at the ATF website, month after week after week, felony in possession of a firearm is a very common crime.
Yes, it
that
is.
they've arrested people for. Very common.
And not only federal, but in Missouri we have a statute, felon in possession. So you could find yourself getting multiple time, because there's no such thing as double jeopardy, it seems like half the time. But usually you're only going to find yourself in trouble in one state. I've had many clients charged with felon in possession in state court. The feds file the same charge and the state dismisses. I can't even think of one time I've had the person get sentenced to prison on both cases, but they're getting sentenced to prison, not probation. I will say that.
Oh, I have one client who was sentenced to probation.
Lucky.
He did not go to prison, and the feds have got nothing else to do but send people to prison.
Right.
Of course, he went out and committed another crime, got violated all over again.
No.
It's sad when you have
I change the subject, Kevin, we have a question in the Q&A. What is the minimum age of a driver to possess, not purchase, but just possess a firearm in their car? Is there a difference between handgun or long gun? If a 16-year-old has a hunter's education certificate, can they hunt by themselves? Wait, they can hunt by themselves, but can they drive themselves there? Did you get all that? I can repeat any of it.
I suppose they can drive themselves there. They've got to have somebody with them in order to possess a firearm like that. And there's some exceptions if you're on for farm kids, but in general, you have to have an adult with you. You have to be at least 18 to possess or have access to a firearm.
Right.
Although you have to be 21 to buy pistols. If somebody gives you a pistol as an 18th birthday present, that's legal. And he can possess that, he can carry that, he can shoot that. If he's 19 years of age, he can get a license to carry the pistol. In Missouri, other states have different rules.
Right. And you mentioned
before we get away from felons, a felon in Missouri, and I stress in Missouri, can hunt with a muzzle-loading gun.
Right.
That is a replica of an antique. So if Jesse James could recognize that gun, the felon can possess that under state and federal law. But God forbid you should cross the state line without checking.
It's not the same in every state. That's good information to know.
Yes.
The other thing about felons is the bow season, they're not exempt from the bow season. They're allowed to hunt with bows as well, correct?
Yes, yes.
So one thing, this kind of takes me into the next topic. The next topic is in Missouri. Years ago, we had almost no expungement statute. If you'd ever been arrested and pled guilty or became a convicted felon, you were stuck. There was no undoing that, so to speak. Missouri has created a pretty robust expungement statute, meaning a lot of crimes can be expunged, including convictions. If you're a convicted felon, you can basically undo it. The statute says your rights are going to be restored to you as if you had never been arrested or pled guilty to this charge. However, as much as we're trying to help people in my law firm, we're actively trying to help people get expungements because it helps them with jobs and housing and voters' rights. I mean, there's so many reasons that what you did at 18 or 21, that burglary, stealing, drug charge, there's reasons to help you get with an expungement, but guns aren't 100%. You're not protected 100%. You are in Missouri. The Missouri statute will not allow you to be charged with felon in possession. It's the feds that are causing some trouble and saying that your rights aren't 100% restored to you. Let's talk about that for a second, Kevin. What's your experience?
That's been an aggravation for me and some of my clients because the feds say, well, the conviction is not completely erased from the government's computers. It can be used, I think under the Missouri statute, it can be used to increase the penalty if you make another felony.
Right, so it's not really a true expungement. Right, it's not a true expungement because they created that loophole that the government can use it against you in the future.
Yeah, and several states have had the same problem. And they're just arbitrarily denying people the right to buy guns in shops, in federal shops, if they have an expunged conviction on their record. And if the government can get this information. Now, under state law, they can possess a firearm.
Right.
But it's a situation where if a state police officer stops you, knows you have that conviction in your history that's been expunged, he cannot arrest you. But the federal officer right next to him can. So
The reality, though, Kevin, is the federal officer's not right next to him. Typically, federal officers are out doing other things, not associating with our local cops. What happens, though, don't you agree that what happens is you've gotten yourself in trouble with this local law enforcement agency. Most likely violence was involved with this gun or drugs were involved. Those are the two reasons they're going to call in the feds, to get you, not just for the violence, the drugs, but also for felon in possession. Don't you think that's the reality of what's happening?
If you don't even really have to tick them off. They can call the federal agency and say, we got this guy, he's got, we can't do anything to him. You want him? And of course, everybody wants to bolster their statistics, so they'll hustle right down there and get him. And it can be very insignificant. There was a case in Iowa where a felon moved into an apartment. When he cleaned it up, he found a single .22 caliber bullet, threw it in an ashtray. Police show up for some reason, see the bullet, and the guy got 18 years in prison for possession of a bullet.
Right.
That's insane, but welcome to our world.
Yeah.
It doesn't have to make sense, just the law.
It doesn't have to make sense. It's just the law. That's so true. And it's a bullet, like you said. It's not just the firearms, it's bullets. So.
And we're a bulletproof vest. Under federal law, people with felony convictions cannot have a bulletproof vest. It's because of those guys in North Hollywood that shot it out with the police. Oh,
I didn't realize the bulletproof vest was also included. We have another question on this topic. If a person is charged with a felony and they take an SIS and they successfully complete their SIS probation, will their rights be restored? Well, their rights were never taken from them, Frank. They had a suspended imposition of sentence, so no sentence was ever imposed against them. The only thing is while you're on probation and parole, and most likely your judge issued a probation condition that you cannot possess a firearm while on probation. It's a condition of your probation, but your rights weren't taken from you. Now, when you successfully complete, no one's watching you anymore, no judge and no probation officer, so you can have your guns back. Go hunting again.
And you can justifiably claim on the ATF form that you have not been convicted of anything.
Correct.
Which is a great distinction.
And
now, if you've had an expunged crime and you go to the sheriff to get a license to carry, you have to tell the sheriff you had this expungement. But then again, you get back to the federal problem.
Right, they're not going to issue a carry concealed for someone with an expungement at this point. But I will tell you that we're working actively, the Missouri Association of Criminal Defense Lawyers is working actively in Jefferson City to try to fix our expungement statute so that this loophole is out of it. Because other states have written statutes that the feds honor their expungement and allow them to own weapons again, possess weapons again, right?
Right.
Yeah, so it's not impossible. It's just we need people like yourselves working on your legislators in Jefferson City and saying, you guys have to fix this because it's not fair that someone, something you did at the age of 21 is haunting you when you're in your 50s. It's just ridiculous. Now, Frank asked, what about the same scenario with an SES? That is a legal term for suspended execution of sentence. And it means that when you pled guilty, you were sentenced to a term of jail or a fine or prison, and it was not executed. They suspended the execution. You are a convicted felon in that circumstance if it was a felony charge. But the SIS, you're not a convicted felon. You are just, but you did plead guilty to a felony. But truthfully, you can answer that question, I'm not convicted.
Right.
Okay. So the next thing I want to talk about is a pretty hot topic. I've talked about it before. I taught in May a legal seminar for lawyers, and I talked about medical marijuana and your rights, the criminal rights, and gun rights was a hot topic. If you, and Kevin, I'm going to let you address this too. If you have a medical marijuana card and you possess a gun, you're going to find yourself in trouble federally. if you go to apply for a lawful weapon at a gun dealer and there's a form you have to fill out, and if you say you don't have a medical marijuana card, you just committed fraud. That's a federal felony. If you admit to it and say, yes, I do, I'm a rightful owner, we have a constitutional right in the state of Missouri to medical marijuana as a valid treatment for our medical conditions, and I do have a medical marijuana card, and you check that box and admit to it, you will be denied a gun sale. But is it illegal to possess a gun that someone else gave you, or you bought before you got your medical marijuana card, or whatever, it was a gift or whatever, or inherited? A lot of families pass guns through the generations. Let's talk about the balance of these two things. People who want to have their gun rights and their constitutional right to use medical marijuana.
Well, you can't have both. The federal statute says it's a felony to possess a firearm if you are a habitual user, not an addict, just a habitual user of a controlled substance, unless you have a but the feds don't recognize prescriptions for marijuana. They consider marijuana to be a controlled substance. So if you have a marijuana card, you signed away your right to possess guns.
The other thing is this: in Missouri, other states are different, but in Missouri, it's not a prescription to medical marijuana. It is a card that was granted to you, and you fit the categories. You are one of the categories, and a doctor had to put you in that category. But it's not a prescription. You didn't go to the doctor and get a prescription like you did for, pain relief or Xanax for anxiety, for example. The other thing is that the feds still call marijuana a controlled substance. And as long as it's categorized as a controlled substance under federal law, you're not going to be able to possess marijuana and a gun. But technically, you're not even supposed to be able to possess marijuana. And we have 30-something states that have medical marijuana or marijuana recreational use of. And the feds have come out publicly. You can Google this. You'll read it across the country. The feds have come out, including in the Kansas City Star, have come out and said, look, we're not paying all that much attention to marijuana if your state says you are a lawful possessor of marijuana, except there's like 5 categories of we are going to start paying attention to you if there's guns with marijuana, if there's violence, if there's a list, and you can find the list. But when it comes to your gun rights, it's important to know that there's an imbalance here. You're not going to be able to have both, but you're also not going to be able to have drugs of any kind around guns. I have clients right now who have reached out to me, too, in particular, who had marijuana in their vehicle, not medical marijuana. They went to Colorado, they bought some, they brought it back, and there's a gun in the car. Guess what? That's a felony.
Yeah, no question.
How do we defend folks who have a medical marijuana card? Have you had any of these cases yet, Kevin?
I haven't had any of these cases. I had a lady who, for no particular reason, told some officers that she smoked marijuana because it was a herb, not a drug, and also told them that she had her father's shotgun and 38 in the house. And they turned the information over to the feds, and the federal prosecutor wanted to charge her with a misdemeanor rather than a felony. So could she have done something else that was a misdemeanor, like carry a gun into a post office? And yes, she probably did, but it was a difficult thing to explain to her because she smoked so damn much marijuana.
What Kevin's explaining is that sometimes we have prosecutors who aren't trying to throw the book at someone, and I have to say that's not always the case, Kevin. And that's the luck of the draw. You don't want to find yourself in trouble. All the time I tell clients, well, you just got in trouble in the wrong county. with the wrong prosecutor, with the wrong judge, because had you done this in Kansas City, you would not be dealing with this. You wouldn't have gone to prison for that. If in Kansas City, you probably would have gotten probation or a misdemeanor. So location matters, unfortunately. Then you narrow it down to the culture of a prosecutor's office, the culture in the judiciary of that county, narrow it down then to the individual biases and prejudices of a particular judge who might not be, they might not believe in medical marijuana, or they might not believe in guns. It happens that you find yourself in that position, and it makes it more difficult. Does anyone have any questions about medical marijuana? I'm not seeing any questions. Feel free to have questions, and I'm going to move on because there's another topic I want to talk about. Lawful gun owners. If you work at a place that has a policy that there are no guns on premises, you potentially can lose your job. We can't help you. You will lose your job if you have your gun in your vehicle and your boss finds out about it. Let's talk about that, Kevin, how the employer's policy.
I've had people call me up with that exact problem.
Yeah.
They left a gun in their car out in a public parking lot, right, not owned by the business. And somehow the boss found out about it, and they were fired. What can we do? Absolutely nothing. They can fire you because you wear a T-shirt with an image of a gun on it. Right. They can fire you because they don't like your socks. That's Missouri labor law, and I think it's their attempt to try to force you to join a union. But it's not a crime.
Right.
But you will be fired.
If your employer wants to fire you, they're going to find a way. We have the Missouri Human Rights Act, and they can't fire you for race, sex discrimination, disability. You know, we have reasons they can't fire you, but they can certainly fire you if you violate their policy.
And if you have an Afro pick, they can't fire you for being African American, but if you have an Afro pick, that fits the definition of brass knuckles, and they can fire you for having a weapon on the premises.
Really? I've never heard that. Brass knuckles? How does an Afro pick compare to
brass knuckles? Well, you should read my book. It can happen. It can happen. I haven't heard of it happening, but I bought an Afro pick on Independence Avenue, and it fits the definition of brass knuckles.
That's crazy.
So do ice scrapers.
Ice scrapers? A plastic ice scraper?
They don't have to be brass.
Interesting.
And you can own them if you're a collector, and I'm a collector.
You're a collector of many things, Kevin. You also collect guns, don't you?
I also what?
Collect guns?
Oh, yes. Yes. I collect weapons of various kinds.
I've seen them. You've presented at seminars and brought them in huge cases to show us your collection. Not all of it, I'm certain, but parts of it I've seen.
Yeah.
Let's talk a little bit about, we've touched on self-defense, we've touched on defending property, but we have what's called the Castle Doctrine in Missouri. And I'm not sure if that's a public phrase or just amongst lawyers. I feel like it's something that you all have heard, the Castle Doctrine, how you have the right to defend your own home and defend your property and defend, you didn't used to be able to defend your property with lethal force of using a firearm, and now you do have that right. And then we've seen cases across the country, like down in Florida, there was that famous case where the details are not coming to me in that name. I knew off the tip of my tongue for the longest time, but if someone was defending their car parked on the street, that's their property, and they had the Castle Doctrine extended to their car. Let's talk about that. In Missouri,
the Castle Doctrine is your house, certainly the curtilage, the yard around your house, and probably all the property that you own or rent. And also your car, wherever that car happens to be, whether it's moving or parked. And there was a case in the 1880s where your office, a lawyer was attacked by an unhappy client. He burned arraigned him with a notary seal, and the court said, it's defendant Castle Doctrine applies because he owns the office. It has become expanded. Now, it's a concept that dates back to the 9th century in the old country, but the concept has expanded in recent years in Missouri. It's not just inside your house, it's outside your house as well, as long as it's on property that you own or rent, or in your car. And as a practical matter, the standard ground law expands it to any place that you are where you can legally be. So if you're on the sidewalk, the standard ground law makes an expansion of the Castle Doctrine for all practical purposes. But if you're in somebody's yard where you don't have a right to be, it does not apply.
What if you're a guest and your neighbor says you're welcome on their yard? You have a right to.
There was a case just like that in southern Missouri. The guy was over at his father's house, acted in self-defense, claimed Castle Doctrine, and the prosecutor pointed out, you don't own the place, Castle Doctrine doesn't apply. And reading the appellate decision, they bent over backwards to find this guy not guilty. It's a rare decision. And then the legislature changed the law to say if you are a guest in that house, you can employ Castle Doctrine. So that's one for the good guys.
In other words, we can use the Castle Doctrine to defend ourselves, but keep in mind, you've been arrested. You need a lawyer.
Yeah.
You're now spending thousands upon thousands of dollars to protect your reputation and your freedom. So that's what's most frustrating about gun laws, is that as much as we all talk about our right to bear arms, the prosecutors are the worst, and even the cops are the worst. It's like they're all afraid of gun owners, and they don't analyze a case and say, oh, self-defense, oh, Castle Doctrine, we're not even going to charge the person. And that's what's so frustrating, is you have to hire a lawyer and we have to defend you and hope that a judge or a jury, depending on where we are in the process, because certainly the prosecutor, what I hear often out of prosecutors' mouths, particularly the ones who don't own guns and have any history with guns, they say things like, well, it looks like a crime, let's let the jury decide. How stressful is that? You're facing potentially, depending on the statute, you could be facing life in prison. And you have to spend money to defend yourself because the prosecutor says, basically, let's shoot craps and see what the jury says. It's not fair, but it's the world we live in.
I have seen a lot of police officers are gun guys, and they're on our side. That's fine. As long as you don't take them off. If you start telling the responding police officer what the law is, and I know my rights, that sounds like a jailhouse lawyer to him, and he's going to arrest you and see what the prosecutor makes of it. And I telling the police what the law was and how they didn't know his job, and he was generously telling them how to do it. And if they didn't believe him, he was going to call Kevin Jameson. Stop using my name. And he locked himself into a bad case, a bad sequence of events, and he got convicted. If he just kept his mouth shut, I might have been able to do something with it, but I don't do miracles.
Sometimes the police have the ability and the discretion to not charge you, not arrest you. Excuse me, they can't charge you. To not arrest you, the prosecutor has the discretion to not charge you. But if you, like you said, if you've pissed them off, or in your past pissed them off.
I was trying to not say pissed off, but since you set such a bad example.
They're saying, Kevin, that they're losing the audio. I'm going to move the phone once again and see if it helps. Can people hear better now? Kevin, say something and we'll see what they say.
Well, if you treat the police officer with politeness, like Ms. Manner says. He may give you the benefit of the doubt. The prosecutor may give you the benefit of the doubt. The jury may give you the benefit of the doubt. But it starts.
What you just said, oh, someone said sound is good and then spoke too soon, bits of sound. I'm going to say something here on this. What Kevin was just talking about was how you talk to law enforcement. And if you imagine that every encounter you have with law enforcement is being videoed, assume that they have a body camera on and that you're going to get to watch this later, you or your lawyer, or God forbid, a jury. Just imagine that everything you say and how you act is being recorded and is going to be seen by someone else because you're being judged. Just like the officer's judging you in that moment. And if you are not handling yourself well and being kind and generous, like Kevin was talking about, a client who's screaming and yelling at the cops about, I know the law, I know my rights. And that's usually the guy that gets arrested rather than the guy that says, I'm sorry, I thought I could do this. I thought I had the right to do this. I went to a class, I read a book, I went, and have a conversation as opposed to a yelling match. You're going to find yourself better off.
Kansas City police are going to start wearing body cams.
Right.
And many other officers do already. And they will play that in court, at trial. And if you're yelling, screaming, swearing, frothing at the mouth, and my favorite is the t-shirt with the Al Pacino character from the movie Scarface, say hello to my little friend. I've seen people wear those t-shirts into court on drug charges. And they should just get a t-shirt that says, convict me now. It's everything that you say, everything that you wear will be presented in evidence against you.
Everything that you wear. I've had many conversations with clients about what they wear to court, and that includes not just clothing, but jewelry, body jewelry, tattoos. Sometimes tattoos need to be covered. You're dealing with, you have a right to do what you want to do, but we, the lawyer, can tell you which judges have biases and prejudices against which things, and it's important to know these things in advance. There was a question early on, and it was, how about possession of switchblades, automatic knives? And automatic knives we need to talk about because there's a specific definition to switchblades. But in public or in your car. And I want to make sure that people can hear you, and if they can't, I'm going to repeat what you say, but possession of switchblades in public or in your car is the first question. The second question is, does having a CCW permit have any legal bearing on your ability to carry that switchblade?
All right. A switchblade is a knife, a folding knife that opens with pressure to a button or other device. Right. Federal or state laws is essentially the same. If the blade comes out the side or it comes straight out the front, it's a switchblade. It doesn't make any difference. And if you carry this in your car or on your person, I say it's legal in Missouri because it's the Missouri statute says it's not a crime unless you're violating a federal law. So that means you have to violate the law on some federal property because of the way the federal statute is worded. Now, given that I've got a client who's facing a possession of a switchblade law in Lafayette County, and they read the same words that I've read, I trust.
They mean
and they think it's a crime.
They mean the prosecutors read the same statute and has decided they're going to charge a crime for possession of a switchblade in Lafayette County. Is that right?
Yes. And all he did was possess it, didn't use it. Now, granted, that wasn't very bright thing for him to be carrying the knife because these things get you more attention than you really want. But some prosecutors could twist the wording of the statute to have you arrested. So, and some cities has local ordinances against switchblades, brass knuckles, and martial arts weapons. And all of these weapons get you more attention than you really want. So if you can legally carry a gun, what are you carrying a knife for? A switchblade. If you want to carry a knife, you can carry a kitchen knife. You can carry a pocket knife of 4 inches or less. You can carry a sheath knife. You can carry a machete. It is not completely legal. Well, to carry a concealed knife, it's a little vague if that's a crime or not. If you have a license to carry, I would say it says you're exempt from Missouri concealed weapons law. But the next statute over says you can carry concealed firearms, not weapons.
Right.
So it is conceivably possible that you could be charged with carrying a concealed knife, but not the concealed gun right next to it. And I think it's a stupid argument, but we see so much stupid. And if anybody hears of such a case, please call my office because I want to hear about it.
Yes, Kevin doesn't just defend folks with gun charges, knives as well, and so does my firm. We find ourselves, I grew up in a family where my dad carried a switchblade in his pocket everywhere all the time. He probably still does. He's in his late 70s. It's very old school, I think, for people to carry switchblades. Those are not typically the people who are getting charged with crimes. It's usually our younger generation that the prosecutors are more biased and prejudiced against. But I've also had cases where I'm really surprised where an older gentleman who's kind of doing it the way he's always done it gets in trouble. And some of these counties don't care. So I don't know. It says we're losing Kevin's audio. Let's see here. No, that was an old message I accidentally saw. Okay. Well, Kevin, it's 17 after 2. We're going to take the last few minutes of this program to take questions and to kind of wrap it up. I wanted to make sure I talked to everyone about Kevin's book, Missouri Weapons and Self-Defense Law is the name of it. And you can get it from his law firm, ordering it from his law firm specifically. Unfortunately, it's not on Amazon. But his Kevin Jameson, if you Google him, you'll find him. Kevin Jameson Lawyer should get you there. Kevin, what are some of your closing thoughts that you want to give to people? We've talked a lot about the laws and some of the laws that aren't very fair, some that people probably never even knew of, but you talked about mismanners, being smart, being kind, being careful, no drugs, no alcohol, and you still can find yourself getting in trouble. So what are your closing thoughts?
Well, in my concealed carry course, I teach a block of instruction on manners because that's the best way to stay out of trouble.
Yes.
If you're crossing a state line or other jurisdictional line, check handgunlaw.us. Get the stay out of jail card and keep it in your wallet or your purse or however, and refer to that if there's any questions. There are 6 categories of places you cannot carry a firearm under federal and state law, and it adds up to I think 17 different types of location. But if you're familiar with that, you're not. And if you make a mistake and somebody sees your gun and they get upset about it, apologize. I'm sorry. Walk out. Walk away. Now,
Yeah, don't get angry.
Call the police and scream, "Man with a gun!" Well, you walked away.
Don't get. It's not just walk away, because if they feel uncomfortable, like you said earlier, and they can say you were somehow angry or threatening in any way, and it just takes their accusation, whether they're right or wrong, it takes someone's accusation to get you arrested and potentially get you convicted and in prison. So the best thing you can do is to you know, apologize and say, I'm so sorry, I didn't know this would scare you or offend you, to not just walk away, but to actually apologize. The other thing is,
Yes, it's not groveling. It's and I've been in the Army, and I had a lot of grizzled old sergeants salute me because I was a lieutenant. But you're not groveling. Weren't groveling when they saluted me. You're just staying out of trouble, which is what you want to do. And if they scream "man with a gun" and a police officer shows up, so you be very polite to the officer, tell him what happened, you apologize, you're walking away from the problem.
The other thing, Kevin, in addition, and one of the members, one of the attendees actually said this, exactly what I was going to say, is don't forget the power of your ability to videotape this, because it's the only protection you have. Just like that African-American gentleman who was filming that woman who was saying, I'm going to call the police and say a black man attacked me, when he was saying something about her dog. And had he not been filming that, you know how he would have been arrested? She would have had her job and stuck with that lie, and no one would have punished her. And she would have had that man arrested, charged, and potentially in prison. So the power of your ability to videotape, and not just videotape it and put it on your phone, but make sure it goes to your cloud, not just on your phone, because phones can be destroyed. They can grab that phone out of your hands and stomp on it, and make sure your video is always in the cloud. Kevin?
I teach a block of instruction on how to talk to the responding officers. And if you just shot somebody, they're going to come in hot and heavy, pumped with adrenaline. And I told people when they show up, follow all the orders, say, yes, officer, and ask the officer to talk to me. And sometimes they do. Sometimes they throw the phone down. But, you know, I tell the officer, hey, no lawyer got sued for malpractice after telling his client to shut up.
Right.
And they understand that. They know that. That's what they tell their kids to do.
Right, that's true.
So,
Kevin,
yes.
One of our attendees found your book on Amazon. I'm sharing the screen right now.
Really?
Whoops. It didn't share. Hang on. I think it shared.
Somebody found it on Amazon, and they were charging $400 for it.
Well, and now it's $23.95 on Amazon. I just shared my screen so that people could see it.
Well, if you come by the office, I'll sell it for 20.
There you go.
And you'll save the postage too. My website has some updates on the book because it's printed in 2003, but it's got a lot of history in it that some people may enjoy.
Craig is an associate in my law firm, and he's watching this video, and he posted in the Q&A section something that's so true. Imagine anything that you do gets an evidence sticker put on it, is shown to a judge or a jury. And that goes back to, you know, filming to protect yourself, but also knowing that your behavior, and you're being judged for your behavior in a one-on-one conversation, but you're really being judged for your behavior by a jury, because every encounter with law enforcement most likely is being recorded on a dash cam or a body cam at this point. And hopefully more and more body cams, because based on what's happening in the world today, we've seen the need for body cams, and they don't just protect us, the public, they protect law enforcement, because people who want to lie and hurt someone will do it against law enforcement too.
Fast draw your cell phone. Not
fast draw your cell phone.
That's the most important thing. You'll never have to fast draw your gun. You will have to fast draw your cell phone.
And I want
be the first person to report an incident.
Be the first person to report an incident, you said. But the other thing is that fast drawing your cell phone in front of a law enforcement officer can get you in serious trouble if they think you're drawing a weapon.
Yes.
So be careful.
Yes.
Be careful.
Yes.
Your phone hopefully is not, you know, in your back pocket where they think you're going for a gun, because there are people who have died for that exact move.
Yes.
So I don't see any more questions. I'm just gonna say thank you, Kevin. This has been a great conversation about what we do for a living and trying to spread the word so that people don't become our clients. As much as we are, enjoy helping people and running a business, and this is our livelihood, we also want people to be safe, and people to not need us is the greatest thing we can do for the public. Oh, we do have a question, Kevin. I spoke too soon. If I'm carrying pepper spray for dogs and I use my firearm for self-defense, can I be blamed for not choosing the pepper spray? Yes, you can.
Well, you can be blamed for it, but I think it's a defensible action depending on how dangerous the situation was, how close the dog was.
Exactly.
Or the bad guy.
Can you be blamed for not using it? Yes, just like I have.
Not using it? Well,
can you get blamed for not using the pepper spray and choosing the gun instead? And
yes.
The reality of the situation is, and someone just said, what about on a windy day? But the reality of the situation is you're being judged for everything that you do, right? And they're looking at what you do and they're saying, well, you coulda, shoulda, woulda, and you're going to get arrested and charged based on the opinion and the biases and the prejudices that go within that opinion of a prosecutor who, at least in my county, almost all of them are children, it feels like. They're all younger than me. Not one is within a decade of me, I believe. And that's sometimes what you're dealing with, is lack of experience, lack of wisdom. Sometimes you're dealing with silver spoon kids who have never, ever had an encounter with law enforcement, and it's shocking how much discretion they have and how much power they have. So yes, you can be blamed and you can be judged, and you also can be...
If you use pepper spray and under mistaken belief you're being threatened,
right,
it's a lot easier to come back from that than if you fire your gun.
Yes.
So if you can carry both, God bless you.
And the other reality is that when you're in the heat of the moment and your adrenaline is pumping and you're scared, so you're not thinking. But when that incident is over and there's a dead dog or a dead person, people are judging you harshly, and it's not always in your favor. You could be right and you still have to defend yourself. So it's better to be smart and careful and cautious. And there's no amount of training that'll get you ready for a scary attack or a scary moment. There's no amount of training. That's why law enforcement find themselves in such hot waters, because they're not trained well enough to handle these mobs or groups of people or even a one-on-one incident. We've seen footage of things like that in Kansas City recently, and it's all across the country. Well,
I had a client who shot a dog, and the responding officer, he tried to explain why he shot the dog. The officer wouldn't listen to him.
Right.
Every time he opened his mouth, the officer, you just decided to kill a dog today, didn't you? Well, no, that wasn't. And when I dug up a bunch of witnesses who said this is a vicious dog, just had attacked people in the past, and the prosecutors were absolutely stunned because they thought they had a slam dunk conviction here, and the guy hadn't done anything except stop a vicious dog.
Right.
Sometimes they won't listen to you, but they will possibly listen to me or you.
Yep. And that's the thing, is that we're having to defend people who are right. It's not always defending people who are wrong. We often have to defend people who are right, and the government is wrong. That's why we do what we do.
Yes.
I'm going to end this now. Kevin was saying thank you so much. We've had a few people saying thank you to us on the participants, and we love doing this. In fact, my firm is doing this at least once a month. I announced that at the beginning. Later this month, I'm interviewing Dave Suroff. He used to be a public defender with me years ago. He now works at a big law firm in Kansas City and helps families who are caught in the juvenile justice family court situation.
Oh, God.
And we're going to talk about some of the stuff that's going on in the world today as far as the George Floyd incident, what we're seeing happening in Kansas City. Dave has a very personal, unique story to share on that topic, and we're going to do that later this month. And then on July 2nd, we're going to do a program in the evening, because I've decided that most of my programs had been during the day because lawyers will take time out of their day to watch a legal seminar and get credit for it. But for the average individual who were wanting to watch these seminars that are for the public, we're thinking after 5 o'clock will be great for them. So we're going to do one on July 2nd. Craig Napier and I, who's the associate at my firm, Craig Napier, we're going to talk to folks about how to help your kids stay out of trouble. What do the kids, top 10 things the kids need to know and the parents need to know to help you prevent your child from getting into legal trouble. Summer is beginning and kids are out. Well, summer is beginning. It feels like summer started about 3 months ago with COVID, but kids are out and they are potentially getting into trouble and mischief, and we want to help those kids and those parents know the top 10 ways to stay out of trouble. That'll be July 2nd. So please watch the website for future ads, or excuse me, the Facebook page is where we're publishing most of our ads, but the information will be out there on the website, and I believe Twitter as well. But thank you all for attending. Everyone stayed to the very end. Kevin, thank you so much. Sorry for this difficulty with the video audio.
Anytime.
Thank you, Kevin. Thank you, everybody.
All right. Bye.
Bye, guys.